this is the Orange County Sheriff's Office, that's public record, so eventually, like, this all will come out.
I'm leaving it like this, please. I'm leaving it like this. I did not intentionally do this. No malicious content or effort was towards this. No malicious.
I would say, does that help you sleep, but you're not sleeping, so.
Welcome back. While everyone tries to locate Sarah's appeal request, let's take a look at how Judge Cranick made sure her sentence would stick more than a scintilla by allowing Sarah to change her defense and submit all of her documentation and evidence. Judge Cranick played the long game. He gave Sarah and James just enough rope to hang themselves. So, let's watch as James Owens carefully walks Sarah Boone into a life sentence, ensuring she will never dance with the dogs again, but she'll be tussling forever with inmates.
I was able to get the redactions done. I put a disc on Mr. Owens' notebook there, has the case number on it and 3 black dots in Sharpie, just so that a random way of saying what it is.
Excellent. Appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
Number one, Kevin Beck is working on.
Let the record reflect that Mr. Beck has appeared.
For the record, I'd like to make 2 points about this issue, about whether or not I can bring in evidence of prior acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so. One is, Judge, in that 2-minute video, Sarah Boone makes a statement, "That's how I feel when you choke me." And then some moments later, "That's how I feel when you cheat on me." And she's angry at him, and she's talking to him. She's talking to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to when you choke me. That's my first motion.
Okay.
The second one is, Judge, on this...
Before you proceed with the second, is the second intertwined with the first?
No. I mean, it's a similar argument, but related to something else.
Okay. Response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law in our home.
Any other further arguments, sir?
Not on that issue.
Motion's denied. Court, again, is going to rely on the Supreme Court's guidance in these situations based on Holland 916 7 2nd 750 at point 760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of George Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of George Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when George Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent. So she knew when he brought home that second bottle of wine that it was not going to be a good night, and she tried to keep him occupied and tried to keep his mind off of his troubles, because she knew that if he reaches a certain level and is dwelling on his hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his overt act, which she's going to testify to, coupled with the fact of her state of mind based on her past experiences with him in that intoxicated state and the fact that he is violent. So she was hypersensitive to danger and fear. And I think that ought to be allowed in as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically restrain George Torres in the suitcase, to actually use the bat to prevent him from getting out of the suitcase because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? Based on
Well, there's an overt act committed by George Torres, but she was heightened because she knows when he gets to that level of intoxication in that scenario, in that scenario.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable, Judge, due to his degree of intoxication, that he may act violently towards her. And the problem is, a lot of the problem is, Judge, he doesn't remember battering her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him. But she's tired of being beat on. And so that all ties into her behavior, her sense of nervousness at that point. The reason she was so confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
We held these arguments already. The court has ruled there are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act has to be something that is objectively reasonable to cause a reasonable person to believe there's an imminent fear of great bodily harm or death. What the testimony is not that that's what has occurred, that there's, her new testimony is this generalized fear, but you've already read that and you've already ruled on that. And I'll just remind the court that her previous testimony is, it's all fun and games, we're laughing, I zipped the suitcase shut, we're still both laughing, it's funny, and then the decedent says, I can't breathe, and then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe. And then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. And we've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt act. She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you and I say, give me everything you own on you right now, and then you in turn pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that, you pull a gun on me to defend yourself, and then I shoot and kill you, I can't assert self-defense. I can't say, well, Judge Cranick pulled a gun on me and I was in fear of death, because I was the initial aggressor. I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies that she previously has, the court has already ruled there's no overt act, and you've read the transcripts. You know what she has said.
Judge, she hasn't.
Eli and Kim. Okay.
Harper's testified, Dr. Warner's testified.
They have not testified. They have given depositions.
Well, given depositions, but she hasn't testified about the act in question. She hasn't testified about the event in question. She had consultations and evaluations by Dr. Harper where they had discussions that Dr. Harper could relate in her testimony. Dr. Warner can say what was said during the evaluation. Again, both of those were not reported. There may be disputes. I disagree with his characterization of that assessment. But it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. She's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those inconsistent statements.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine, and I know what happens when he gets it, and everything that follows from that, those are bad acts. That is character. And the Florida Supreme Court has provided guidance and circumstances, specifically in Holland, on what needs to be done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything else?
We cannot talk about any prior bad acts or anything of that nature until we talk about the actual event, the attack. Correct? Mm-hmm. You understand?
Do you understand that?
I do.
Okay. Anything else, State?
Nothing.
Defense, anything else, sir?
No, sir.
Jury entering.
State, do you recognize our jury?
Yep, Your Honor.
Defense, do you recognize our jury? All right, thank you. Y'all can be seated. Members of the jury, after seated and comfortable, if you could raise your hands to confirm that you comply.
Born in Atlanta.
Raise your right hand, please. Sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, you could take a seat. And if you could, state and spell your name for the record for us.
Sarah Boone, 101077.
And could you spell your name?
SARAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
I was born in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay. Y'all all moved down from Atlanta down to Orlando?
Yes, and my 2 brothers.
Okay. And were you raised here essentially from that time on?
Yes.
And you've resided here in Orange County, Florida that entire time?
Yes,
Okay. And where did you go to high school here locally?
I did.
Where did you go to high school?
Edgewater.
Okay. And tell the jury, how old were you when you graduated?
I was 18 years old.
Now, I know you lost your mother and father.
Overruled.
I know you lost your mother and father in your teens and in your 20s. Is that true?
I lost my grandfather when I was a sophomore in high school, and I lost my father when I was a senior. And then my mother passed away a few years after that, and then my grandmother passed away after my mother died.
All right, so you were in your 20s when all that was going on?
Yes,
Okay. And then at some point in your 20s, you met Brian Boone?
I did, yes.
All right. And how long did y'all date before you married?
A good handful of years. I helped my family with paying mortgage and bills for the house since my father had passed away and my grandfather, so
So you worked outside the home?
I did.
Okay. Can you tell the jury when you said you and Brian Boone dated for a while? Do you remember when y'all married?
I do.
Could you tell the jury when y'all were married?
The year?
Yeah. Do you remember the date?
It happened to be, yes, that after my mother passed away, that he had waited to ask me to marry him because he knew it would be,
Objection, not responsive.
Sustained.
Just answer the question if you can, Ms. Boone. Are you a little bit nervous?
a little bit.
Okay. Well, just tell the jury if you remember the date that you and Brian Boone married.
August 21st, 2004.
Okay. And had y'all lived with each other for a short time before that?
Short time.
Yes. Okay, after you married, how long was it before y'all had any children?
Gosh, 6 years?
Okay. And y'all have one son.
Yes.
What's his name?
Lucas.
And how old is Lucas now?
Lucas will be 14 years old on the 28th.
28th of this month?
Yes.
Okay. So you and Brian were married, and y'all lived in Orange County. How long were y'all married?
For 13 years.
All right, and y'all divorced?
Yes.
And as part of the divorce, were y'all to share custody of your son?
Yes.
And so y'all would split days? Would that be fair to say?
Yes.
Okay. At some time after you and Brian split up, did you meet George Torres?
Yes.
All right, could you tell the jury how you met George Torres?
I met George when I decided to buck up, I guess, and was tired of trying to patch things up with my ex-husband. And I decided to go one day for a walk across the street and go have a beer by myself and sit and people watch just to get out of my house and a change of scenery.
All right, now is this your apartment?
No, this is the marital home.
Okay. Where is that marital home?
Winter Park?
You're no longer living in that marital home?
No.
Who lives in the marital home?
No one. It has been sold.
Okay. So you met George Torres before you got the apartment?
Yes.
Okay. And you met him at a bar across the street from the marital home?
Yes, we had a mutual friend there.
Were you introduced?
Yes.
All right. How did you and George get along when y'all first met?
Very well. It was strange how quickly we hit things off and had so much in common, and I never thought that he would be interested in someone like me, and I just couldn't believe that he was actually interested in me and said a lot of nice things, and 1 hour ended up being 4 hours from when we had first met, and then we would always have something to talk about.
Why couldn't you believe that he would be interested in you?
He was very handsome. He was very funny. He was smart, and I would show up in workout clothes and disheveled hair, and I guess I kind of felt broken from being in the process of the divorce that he knew about, but then one of the things that we could relate also was the fact that he was here in Florida because he had just been divorced from his second wife. So that was another topic that he and I could compare notes on.
So eventually, the divorce was settled. Did you get your own place?
Yes.
Is it fair to say that after you, at first you lived in your parents' home, correct?
Yes, until I was married.
And then you moved directly in with Brian,
Yes.
and then y'all lived in the marital home, correct?
Yes.
And then you got this apartment.
Yes.
So that was the first time in your life that you actually had your own place.
Yes.
And what was the address?
4748 France Court, apartment number 3.
And what city is that in?
It's in Winter Park.
How far is that from here?
20 minutes?
Okay. So you got that apartment, and initially were you by yourself?
No.
All right, tell the jury.
In the almost year, about 10 months of separation from Brian, my ex-husband, that is the time when I met George. And my ex-husband was trying to buy me out or force me out of our marital home, and I needed to find somewhere to live. And
So did you and George agree to rent the apartment?
yes, I needed extra income. We could not afford it, just on my own.
You were receiving some income from the marriage settlement, were you not?
Yes,
So you did have consistent monthly income coming in from the marriage settlement,
for the most part, yes.
but you needed more to live.
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills and on a regular basis, where it wouldn't be something that I would have to argue with him about. It would just be an automatic, make sure that everything's paid first, and then from there, hopefully have some fun with it.
Okay. And so I understand from that point on, would it be fair to say that y'all saw each other on and off for about the next 3.5 years?
No, I would consider us a couple.
Okay.
At some point, he asked me to marry him.
Okay. But y'all did have times where he left and went to live with his parents.
Yes.
Is that fair?
Yes.
And there were times where there was an understanding that y'all were going to break up.
Multiple times.
Okay. All right. So, again, on again, off again.
Yes. This was actually before we had our apartment. That was, I guess, our dating phase.
Okay. So y'all were together for 3.5 years. Is that fair?
Mm-hmm. Yes.
And y'all had actually agreed to marry?
He had asked me, yes, a couple of times to marry him, and one time I agreed to yes.
Okay. Now, I want to get directly to the date of this event so that the jury can hear your testimony. All right. So tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day, from the time y'all got up, the whole thing.
Approach. For release, are you satisfied with your attorney so far throughout this trial? State, anything we need to address?
Not from the state.
Defense. All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before release. Are you satisfied with your attorney so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial?
Definitely.
All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Regarding the plea offer, it's not just 15 years in the Department of Corrections. That is an offer predicated on a particular circumstance. Coming to court and saying, I am responsible for George Torres's death, and I accept the punishment. And because that consideration was never given in this case, the offer of 15 years in no way represents what this case is worth, or what George Torres's life is worth.
Court pronounces sentence as follows. Ms. Boone, court sentences you to life. Hold for now.
Now, Ms. Boone, let's just, instead of one long speech, let me break you up over the course of the day. So, do you remember the date of February 23rd, 2020?
Yes.
Do you remember getting up?
Yes.
All right, just tell the jury about that morning. What y'all did that morning. What you and George spent the night together at the apartment.
Yes, at that point he was living there.
Yes.